One other good thing is it would buy us a little bit of time for them to get reshuffled.
But before we get any further, we're gonna ask for a shuffle.
All right. All right, and if you could step back right there. Yes. All right, state this, I don't know if this is your case or not, it's Delina Glass.
I believe it is, Your Honor.
All right, so
Yes,
she has a warrant. Does anyone know, is the warrant because the bondsman got off her bond or is it something else?
check off here just to see.
All right, thank you.
Your Honor, facts and after the jury surrender.
Mhm.
And then immediately thereafter,
This one, or I'm sorry.
I spoke to her on the phone yesterday, the day before.
Okay, all right, let's just see what's in the system. And why were you not here yesterday? No? Okay,
I had told her she had a warrant, judge. She had actually contacted me for, she had a warrant. I told her to contact the bondsman and.
I'm gonna turn this in.
I did tell her that I think she would be arrested. I don't distinctly remember saying specifically that, and it could be implied that if you come, you're gonna have.
Aggravated.
Frankly, judge, I'll fall on the court for that. The homicide. So I do apologize for that, but as soon as we can get home, because she goes under that, I made sure that.
okay. All right, and have you had a chance to confer with the state?
And not since last time, I'll put there right now, Your Honor. I know you have a jury.
Oh, no, well, we do have are you available? Oh, well, Jason is available.
Yes, Your Honor.
Okay,
If you haven't seen it,
Deadly weapon investigator.
Yeah.
Caroline, on this one, can I have the B page? It's 2023 CR 3548.
Correct. Okay. So basically, her dogs are gonna be being bullied by. Right, so that should be, and those two girls were going to a fire or whatever. And my client wasn't having it. So then, those other girls come to her apartment.
Oh, you did become a new.
Yeah,
but I
figured
here because it's.
My client,
Right.
mom,
Technically.
no.
Hey,
They're in the course.
You
of
got the
that
new
happening.
NCICTC yesterday,
Uh,
right?
He gives us
This allegation happened. So I mean, we're gonna, if it goes to trial, I believe we have a good defense of third person.
I'll give it
The
back to you.
complainant
whenever,
is, not able to carry.
Okay.
I also
Just let me
believe
make
that
sure not.
the defendant- the
I know,
complainant
I know.
has
Yeah.
a criminal
You did that
record.
last time.
I'll maybe attempt that, of course.
Sorry,
But
dinner
our-
mystery.
our
Oh, yeah,
defense
let's do a dinner mystery. It'll be fun.
is-
Either way, you know what, Christmas time would be great.
Give me a second, I'm just watching the video.
We could either do that or that escape thing. Is that asking a lot? Okay, all right, you're in charge of the murder mystery dinner. Yay, I'm excited.
I mean, I think if it happened at her premises, I think. It's pretty sound.
Yes.
Excuse me. Years.
If somebody else, we could, you know what, that's a decision we need to make. Yeah. Because if my mom is here, she's allowed to come. And then on Delilah Glass, can I have a 30-day reset for that, please?
Say hello.
And it will just be for discovery.
I was reading my phone. I was very confused.
Originally.
Keep this on Tuesday, because this was originally on a Tuesday.
Well, that's not.
What's
That's
this?
the way it reads.
Okay, all right,
Yes.
thank you.
Said she didn't do anything except not.
And if you could do a reset form for that.
Yeah.
That's what I try to look at, help her out.
Oh, Mr. Harris,
Yes, ma'am.
if I could see you around this way for a moment.
Yes, ma'am.
It's Mr. Gonzalez doing it today.
Then break his leg.
Oh, that may happen.
Yeah.
Oh, Daryl.
Oh, yeah, you could. One time before, yeah. Oh, you know, I was gonna be running from home.
Yeah, we're ready. It's always fun. I know it's always fun. No, you're now 40. No. There's always that.
I mean, the complaint.
I mean, it reads a little different. Well, I know you paid it, you didn't lie, but it was very different.
I don't ever like.
I'm not saying you did, it's just a very different rendition of what was written in the report.
Yeah.
We left out the portion where Miss Glass went over to their apartment with a gun,
Yeah, that's,
and then police were called, and she was told to go home. And then they went over there to talk to her the same way that she came over to talk to them, I'm assuming, to say it in the best sense, you know. But then somehow outside of the location, outside of her apartment, she was shot by Miss Glass.
All those.
Yes. So how are you doing this morning? Yes, we're gonna start a trial and we'll see where the day takes us. Oh, yeah. I mean, that's all you can do. So what are you up to? This one? Okay, all right. Well, they've asked for a jury shuffle. So that's probably gonna take, oh, no, just if you all can just come through this way. Because this jury shuffle is gonna take some time. Okay, all right, awesome. I will. You know what, can we change it to Wednesday? Yes. Yeah. Okay, awesome. And then we can do lunch. Okay. Oh, wow. Because I love history. Okay, all right. No. Okay. All right, awesome. Okay, is this a PSI or? Okay. All right, so let's have him come in and then I'll take it up. All right, sure.
Yeah, no problem. Thank you.
It's almost. done.
Oh. I don't think that. At all about. You reminded me that I came in front of that sometime.
Well, put it this way, it's not a dismissal. Like if you go
Not
through
yet,
that,
even though I pretend to be.
stress over again, And if all she wants is a trial, I mean, I can see it being a trial unless, you know, I mean, the victim seems like we just had contact on the 17th. Well, it seems like, you know, it's both.
You'll never think of Kool-Aid the same.
You don't think it should have gone to the level of cheating something.
I cannot believe Vacation is 40 years old. Oh my gosh. We are very old.
I'm sorry, what?
Chevy Chase Vacation.
Oh my
The
goodness.
first one is 40 years old.
What?
I can believe that.
No, somebody did the wrong numbers. That's not true.
Oh, yeah, I think I saw something on there.
I watched it the other day, so it cannot be 40 years.
What's your favorite one?
It's on this-
Uh,
I don't know where it's from.
My favorite vacation? Oh, the first one.
Okay, so which one is the one where the aunt is on top of the car?
First
First
one.
one.
Yes, that's my favorite one.
I think it is too.
I do like the Christmas one though. I like
Yeah.
the Christmas one too.
Yeah.
Yeah.
Oh, and by the way, it is 40 years old.
Stop it. No, it's not.
Yeah, I
Because
like the
then
one where
the-
the aunt
then-
is on top of
no.
the car and she's dead
Yes.
already.
We
Okay,
are
maybe-
so old people.
No,
We're
what it
not.
is I
We're
was
in the
really
twilight of our
young when it
lives,
came out,
like you
and I didn't
said.
watch it then.
Let me just tell you, unless you were one when this came out, we're old. Oh, look at her.
I was close to it.
Caroline said she wasn't born.
Wow. You
Yeah,
didn't have to say that.
Caroline.
You could've kept that.
Yeah, you could have cut that to yourself.
Have you seen it, Caroline?
No.
Okay,
And
well,
I keep
that's
telling
another
her, it'll
separate-
make you see Kool-Aid differently
It will. Can I help you?
and
with that?
sugar.
The eggs on top of the rock.
Yeah. Okay, Caroline, here's your assignment. You must watch Vacation, the first one, and do a book report. I mean, do a movie report. It is.
I think it's easier to say which is the one that I like the least.
Yeah.
I don't think it's fair to say which one I like the most.
I think they should, well,
Which one do
biggest
you
one,
like the
it's
least?
easy.
European.
European.
I don't like those. I mean, it's funny, but I don't like the kids that they had, and
Yeah, I didn't
they
either.
kind of gross. I don't know. They weird me out. They look like cartoons or
It
something.
did
I don't know.
something. That's the weirdest one.
Mr. Papa,
Bacon.
But it's so brief.
Yeah.
So brief.
makes an appearance in your mind? It's in all of it.
but you know, when they started changing the children, it's, let's stop.
Disappears. If you get hungry, eat
I think
something.
each one of them had different
Different
kids. They all, that was kind of their thing.
Yeah.
Every single one had different kids.
Oh,
And
and
they did a reboot
mhm.
that with Ed Helms.
Yeah,
See
even
how-
that one I prefer over Europe, over
Yeah.
Europe.
You know what? Instead of saying,
It's actually pretty funny.
but you know what the problem is? The problem is we say reboot when back in the day, we wouldn't say reboot. They try to say reboot like they're doing something new. No, it's not a reboot.
Right.
Thank you.
It's
a rebranding.
Yeah. But last night I was able to see Justified.
The new one?
Yes. So they showed 2 episodes back to back.
Apparently,
What?
come on, Crumpus. Apparently, the Lincoln Lawyer, the second season, the first half is out.
Ah, yes, it is out.
He shorted us.
Y'all watch it?
Yeah, so the other one will be at the, starting in August.
Well, you know what? I'm just going to wait till it's all out at the same time.
Did you watch the first?
Yeah.
Oh, you gotta.
Oh, no, I watched the first season.
Okay.
Yes,
Did you like it?
yes. But you know, it's still not the same as the movie.
It's not. It's not.
My mom said
Just gave her the
now
best.
only
Yeah.
Matthew McConaughey can play Lincoln Lawyer for her. But I've read the books.
2.
Two small ones. There's someone down.
A small one. And Leo, since you've been in trial with us before, you know the rules with jury selection. Jessica, are you going to be sitting with Leo?
Yes, yes,
Okay.
Your Honor.
You want him to hop on in?
Oh, and everyone is here?
Yeah, can you check over those?
Wow. Because that young man, his sister brought him.
Well, that's the only one that was missing.
Oh, yes. I gave it to her.
Oh, yeah.
All right, can you mute us, please?
Thank you.
Stop video.
This chair, that chair. This chair.
Oh, you know what? We'll have to ask Stephanie Lloyd, like, why isn't their video showing? Oh, she just has to click on things over here.
Yeah, she's not.
Oh, yeah, no, I can. do that.
Like,
Okay, yeah.
Can I?
Sure. Yeah, no problem. Oh, I'm doing great.
First row,
Yeah.
first chair, row. Come on.
And everyone, please don't sit on the cards. Yeah, just, yes. You'd be surprised. A lot of people just sit on there like, I don't have a card. Oh, you may be seated. We're standing for you all.
Number 8. Number 8. Second row on top. With him. They're all in order. It's just all each other. Look at these. 15. Oh, they're right there.
Oh.
22. Place the next row.
Has Tom come to speak to you? I'm gonna send a text message to Tom that you're in the back. You're gonna be in the, okay. Everyone, please be seated. All right, everyone, good morning. Okay, it's 10 now, but it's still morning time. Everybody should have hopefully had breakfast. Good morning, everyone. Awesome. All right, everyone. My name is Judge Stephanie Boyd. You're in the 187 District Court. It is on the 4th floor. So which courtroom are you in? Who's the judge? All right, you guys trailed off like they do on Old Lang Syne. The reason why I asked you all to repeat that is because sometimes we end up having to take breaks because one of you may need a break. And by the way, if you need a break, just do the break sign and either I will see it or one of the attorneys will see it so that we can give you a break. But the reason why I asked you to repeat the name of the court or the name of the judge is because when one person leaves for a break, everybody has to leave for a break. And there are a lot of courtrooms in this courthouse, and sometimes people get lost. And we've had people who we've searched for because we can't continue unless everyone is here. And they are down the hallway trying to go on another jury. So if you're ever lost, if you mention the 187 District Court, because there's only 187 District Court here in Bexar County, or if you mention Judge Boyd, I'm the only Judge Boyd in all of the courthouses downtown, you will never be lost. All right, so this case is the state of Texas versus Roger Saucedo, and I'm going to have the parties introduce themselves to you for the state.
Daniel Escobar for the state. Good morning, Hank Wilkins.
And for the defense.
Gonzalez for Roger Saucedo.
And Jessica Gonzalez for Mr. Saucedo.
And Mr. Saucedo, if you introduce yourself, please.
Roger Saucedo.
All right. And you will notice that there is a person sitting behind. If you could introduce yourself, please.
I'm Shauna Monona here with, oh, sorry, I'm Shauna.
All right. So I always want people to introduce themselves so you all will know the parties. Sometimes we have people who want to come and see court. Sometimes people come to court to support people. And we need to make sure that the courtroom is available and open for them because this is an open court and has to be open. So that is why you have her sitting here and not in the audience because there's just not any room in the audience. Now, to my left is the court reporter. Diana, could you raise your hand? She takes down everything that everyone says. And it's very important that she is able to hear everyone because if it's not taken down by her, it's as though it never happened. So I always try to make people's job as easy as possible when I can. And one way to make her job easy today is one, if everyone will speak loudly so she can hear. Trust me, if you think you are speaking too loudly, people will say, you can lower it a little bit. That's never happened in this court. The other thing is we cannot speak over each other. And I realize that sometimes when you're speaking, it becomes like a conversation. And when you're doing a conversation, sometimes you complete somebody's last words. That makes it difficult for her. And court reporters, when they send up a record, and in that record, it has a lot of blank space, mumbling or whatever they put in that, it makes them look bad because people think that they're not able to do their job. She does a great job, by the way. I always tell her if that ever happens, I'll do an affidavit and say, people were talking over each other. People were talking at the same time. So that will make her job easy. Now, I'm going to give you an instruction. Up until this point, no jury has been able to follow this instruction. I tell every jury, I have faith that you can do it, and then it doesn't happen. So I have faith that you all can follow this instruction. I want everyone to raise their cards. All right. So whenever there's something that you have to say or you want to address something, just raise your card and someone will call on you. The people in the box, if you'll lower your card, everyone else keep your card up. The people on this front row, if you will lower your card. Everyone else, if you still have your card up, whenever you speak, if you can, we will need you to stand because the acoustics in this courtroom are horrible, and that will make it easy for the court reporter to hear, and it will make her job easier. So I have faith that everyone here who still has their cards up, whenever you speak, you will stand. And if you see someone about to speak and they're not standing, just lightly tap them and tell them you need to stand. We don't want to fail this test. All right, everyone, please lower your cards. All right, you've had a chance to see all of the persons who are involved in this case, at least the attorneys. Is there anyone here who recognizes any of the attorneys or any of the parties who introduced themselves? If you do, please raise your card. 34, 55. Here's the beginning of the test. Number 34. Who do you recognize?
Hello, I recognize Hank Wilkins,
All right. And how do you know Hank Wilkins?
friends.
All right. Thank you. Number 55. Who do you recognize?
Recognize you, Your Honor.
Oh, hi.
Hi. My name is Chris Booker.
Yes, UTSA.
Yes.
All right. Thank you so much.
You met one of my interns, Jacqueline.
Yes. She's doing awesome, by the way. All right. Thank you. All right. Now, the charge in this case is aggravated assault with a deadly weapon. And I'm going to talk to you about the nature of that charge in a little bit. What I want you to know, though, is no one in this court is allowed to tell you what they think the facts of this case is. Whenever they speak to you about something, they're going to be talking to you about hypotheticals because they're not allowed to let you know what they think the facts are in this case. So whenever you're answering a question, just remember, it's not about this specific case. They're just talking to you about hypotheticals. Now, the way a case gets to criminal court for a jury trial is a person has to be indicted. An indictment is not evidence of guilt. It cannot be considered in any shape, form, or fashion. Now let's practice raising our cards and let me see how great a drivers we have on here. Is there anyone here who's ever had a traffic ticket? Raise your card. All right, so we have a bunch of horrible drivers here. All right, so lower your card. So I've had a traffic ticket before. And back in the day when I would get a traffic ticket, it would be a sheet of paper and they'd write what they thought your offense was and hand it to you. So whenever you get a ticket, let's say they say you ran a stop sign. When they give you that ticket, that's an officer telling you, hey, I think you ran a stop sign. Here's your ticket. This is where you need to appear. You can go to trial or not. That's completely up to you. So when you accept that ticket, you are not saying I ran a stop sign. That is just a piece of paper to let you know what you're charged with. And as you can imagine, if you're charged with something, you don't want it to be a surprise. You want to know what you're charged with. You don't want to think you're in court for a criminal trespass. And then they say, surprise, we're charging you with aggravated robbery. So an indictment is just to let you know what you're being accused of, where you need to appear to answer. Does everyone understand? Yes. So in this case, with the charge of aggravated assault with a deadly weapon, Mr. Saucedo has been indicted. That's why he's here for trial. You cannot hold that against him. You cannot consider it whatsoever. Does everyone understand? Is there anyone here who cannot follow that instruction? All right. The next thing I want to talk to you about is certain rights everyone who's accused of an offense has in the United States. One of them is the right to remain silent, which means you do not have to testify. So in criminal cases in the United States, no one can call you to testify. Does everyone understand? Yes. Now, why might someone not testify? There are thousands and hundreds of thousands of reasons why people may not testify. I've been a prosecutor. I've been a defense attorney. Sometimes I would have a client and I would tell them, you don't need to testify because the state didn't prove their case. Or either I would have a client who was shy, super nervous, and I would say, the jury may take the fact that you're super nervous and you get on the stand, you're super nervous, they may hold it against you. There are some people who stutter, and there are some people who just cannot do it because it's extremely terrifying to speak in public. So the key to the right to remain silent, though, is if Mr. Saucedo decides not to testify, you cannot hold it against him. You cannot consider it whatsoever. Does everyone understand? This is not like Bewitched with Mrs. Kravitz, where you're over the fence saying, ooh, I wonder what he would have said. And I think he didn't say anything because of this. You cannot consider it whatsoever. You cannot think about it. Is there anyone here who cannot follow those instructions? Next thing I want to talk to you is everybody who's charged with an offense is presumed to be innocent. So that means when you walk through a door and you're charged with an offense, you're presumed to be innocent unless and until the state proves this case beyond a reasonable doubt. So if you had to vote right now on whether or not Mr. Saucedo were guilty or not guilty, what should your vote be? Yes. And that's because you have not heard anything about this case and because he's presumed to be innocent. When I tell people what the burden of proof is, people always want to say, well, what's the definition of proof beyond a reasonable doubt? When I first started practicing in '97, there was a definition. You did not feel as though you were successful in law school unless you knew that definition. I knew the definition. I still know the definition. I know where the pause, I know where the comma is, I know where the semicolon is, I know how to inflect where the period is. I had my first trial, and after that first trial, guess what happened? There is no longer a definition for proof beyond a reasonable doubt. So neither the state nor the defense can give you any information on what that is because there is no definition anymore. So when I was a prosecutor and when I was a defense attorney, I would explain it to people by telling them what it was not. Next door, the historic courthouse with the green rooftop. That's where they handle civil cases, your car wrecks, anything involving money, child cases. Over there, they have two burdens of proof. One is called preponderance of evidence. That means more likely than not, something happened. If you are ever deliberating in a criminal case and you find yourself in deliberation saying, oh, well, I think something happened, more likely than not, I think it happened, then you know you are not using the correct burden of proof, because proof beyond a reasonable doubt is higher than preponderance of the evidence. The other burden they have over there is something called clear and convincing evidence. Clear and convincing evidence is what is used to terminate your parental rights, which means somebody has reported you, somebody has said you're not a good parent, maybe you're a danger to your child, and so they're taking away your legal rights as parents to a child. That burden is a lesser burden than proof beyond a reasonable doubt. Proof beyond a reasonable doubt is the highest burden we have in the land. Does everyone understand?
Yeah.
Now, with regards to the burden of proof, think of it as weights, or think of it as a plant. Those weights and those plants stay on the state's table. They never transfer to the defense. The defense does not have to prove anything because they don't have the burden. So if you're ever deliberating and you find yourself saying, well, the defense should have done A, B, and C, you know you're in the wrong place because the defense does not have to do anything. When we were in law school, we were always taught the defense could stay over there. They could do crosswords, puzzles, play games. Of course, I have not seen any defense attorneys do that. But the reason why in law school they would give us that example was to let you know that the burden is never on the defense's side. The burden is always with the state, and it stays with the state until and unless the state proves its case, each and every element, beyond a reasonable doubt. So the defense does not have to prove anything. Does everyone understand? Now, there are two phases to a jury trial. The first phase, some people call it the innocence phase, but that's really not what it should be called. The first phase of any criminal trial is whether somebody is guilty or not guilty, whether the state proved their case or did not prove their case. So it's not the innocence phase. It's whether the state proved its case or did not. Now, if the state proves its case, then there's the second phase, because if the state has proven their case, then that means you're finding somebody guilty. So you go to the second phase. And the second phase is what's called the punishment phase. And that's where you decide punishment. Does everyone understand? According to our law, anyone who's decided to go to a trial on the criminal side, they have to make an election or a selection of, if they were found guilty, who would they go to for punishment? Now, when somebody is making that election or selection, they are not saying, I am guilty. They are just following the law. And the law says that you have to make a decision. If you were to be found guilty, who would decide punishment? In this case, Mr. Saucedo has made an election that if he were found guilty, the jury would decide punishment. Is there anyone who's going to hold it against Mr. Saucedo for making an election of who should decide punishment if he were found guilty? All right. Is there anyone here who, for religious reasons or some other reason, feel as though if they had to decide punishment for someone, they would be unable to? All right, number 4 and 62
One over here too.
and 8. Thank you. Thank you. Now, I want to talk to you about the range of punishment. The range of punishment for aggravated assault with a deadly weapon, someone may be eligible for probation, or it could be anywhere from 2 to 20 years in prison, and also up to a $10,000 fine. Usually, nobody talks a lot about the $10,000 fine because honestly, the fine goes into a black hole and it's never to be seen again. I've even had my students at UTSA do research on where do fines go and can we track those fines down. So in order to be on this jury, you have to be able to consider the full range of punishment. And part of that range of punishment is up to $10,000. Part of that range of punishment is probation. And part of that range of punishment is anywhere from 2 to 20 years in prison. Now, if you think about it, that is a wide range of punishment. You could give somebody probation. You could give somebody 2, 3, 4, 5, all the way up to 20 years. So the question is going to be not if you would give it, because you don't know any of the facts of this case. And nobody can tell you what they think the facts of the case are. The only thing is whether or not you can consider it. And then if you can consider it, if someone were found guilty, would you be able to apply facts to make a decision on punishment? Now, when you think about charges, for example, this is what I would always see people doing when they would talk about ranges of punishment. If you have someone who has never been in trouble with the law before, and let's say they're deeply in love with their partner, and their partner has a terminal illness, partner's in a lot of pain, and the partner's like, just let me die. And so they assist them by giving them pills so they can die. Under Texas law, that's murder. And the range of punishment for murder is 5 to 99 years of life. Now, in a case like that, you may say, man, I'm not doing a life sentence on that. I'll do 5. Now, if you reverse it, if you say, if there's someone who's always been in trouble with the law and there's a little old lady crossing the street who's been a teacher before and somebody just kills them for no reason, whatever, then you may say, oh, I can see giving life in that situation. So just think of scenarios in your head where maybe you could see giving somebody probation for aggravated assault with a deadly weapon. Or maybe you can see a scenario in your head for giving somebody 2 years, 3 years, 4 years, or 20 years, up to $5,000. So is there anyone here, bearing that in mind, cannot consider the full range of punishment? All right, number 61. 18, 47, 51, 64, 62, and 73. Thank you. Now, the next thing I want to talk to you about is the English language. I love languages. When I was in school, in undergrad and graduate school and law school, there were so many of my classmates who spoke so many different languages, and I thought it was great. I'm not originally from Texas. I'm originally from Louisiana. So you can tell where I thought I would be by the language I decided to speak, even though my classmate, Tanya, was like, Stephanie, take Spanish. I'm like, I'm going to be retired at 21. I'm going to be in Paris. I need to take French. So I took French, but I'm here in San Antonio. So I pretty much know how to say, hurry up in almost every language, because that's what my classmates were able to teach me. I had some classmates who were from the Middle East. They spoke about 8 different languages. Some classmates who were from Mexico, they spoke about 3 languages. I learned some Navajo while I was in school. So I was able to pick up on different languages. Is there anyone here, and raise your card, if English is not your first language? All right, 1, 2, 8, 15, 19, 32, 33, 48. And we always, 15, I have you, and 56. A couple of times we've had new languages. Let's see what we're going to have here. Number 1, have you been able to understand everything? How do you say hurry up in Spanish? Is that the only way to say it? What's the other way? Thank you. All right. Number 2. Yes, you're the second one we've had. So what is your first language? And have you been able to understand everything? All right. How do you say hurry up in Vietnamese? All right. You got that down, Diana? All right. Number 8. Number 8. Spanish. All right. And I've already heard you tell him the second way to say it. He was a little bit nervous, but you saved him. Have you been able to understand everything? Number 15.
Spanish,
All right. Have you been able to understand everything?
the majority.
All right. When you say majority, what do you mean by majority?
I'm not so sure about the applying of the extent of the law and
Okay. All right. Thank you for letting me know. I appreciate that. Number 19. Yes.
Spanish.
All right. Have you been able to understand everything?
Kind of.
All right. How long have you been here in the United States?
Mm,
More than 10 years?
30.
30 years? All right. Did you attend school here?
No,
All right. Oh, where did you go to school?
in Mexico,
What's the name of the school?
in Chapala, Jalisco.
All right. Thank you.
Mhm.
I'm always interested. I love education. Number 32. Thank you. Yes. All right. What's your language?
My language is Spanish, but I speak more English now.
All right. Have you been able to understand everything? All right. Did they tell me the correct way to say hurry up in Spanish?
Yes. Hurry up, apúrate, adelante, may come forward.
Okay. All right. Thank you so much. Number 33.
Spanish,
And have you been able to understand everything?
yes.
All right. Thank you. 48.
Spanish,
And have you been able to understand everything?
Yes.
Thank you. 56. All right. And have you been able to understand everything? All right. Thank you. All right. The next thing I want to talk to everyone about, and if I could, because sometimes people are shy, if everyone can close your eyes. All right. And if you could raise your card if you have any pending criminal cases. Just raise your card number. All right. Thank you. All right. Everyone, you can open your eyes now. Next thing I want to talk to you about is time constraints, travel arrangements. If there's anything where you have a plane ticket and you can't put it in my name, let us know. All right. So here's the thing. I do not expect this trial to go into August, but sometimes people want us to be jealous and they want to tell us about their European vacations in August. So if you wish to do that, you still can, but we're just probably looking at to the end of this week, potentially maybe Monday at the latest. So if anyone has any time constraints around that time, please raise your card. 1, 3, 4, 5. And as I call your number, if you can lower your card, 15, 16, 18, 25, 28, 30, 34, 35, 37, 47, 48, 49, 64, and 70. All right, number 1, what is your time constraint? Okay,
Monday, my father has, appointment. I have to take. Tomorrow. Saturday, shower at, shower by 2. He doesn't want me in with that. My daughter has.
Mhm. Alright. So here's my question, and everybody's under oath because they were sworn in downstairs. Are you planning on passing out in the delivery room, or are you just gonna actually be there to help? You're not gonna pass out. There's not gonna be any video where you've passed out. Okay. All right, number 3.
Yes, Your Honor. Friday, I'll be leaving out of town.
And where are you going?
I have a non-refundable reservation in South Padre.
What are you doing in South Padre?
I'm spending time with my family, I'm a single mom of 3 kids,
Okay. All right. And when is that?
this Friday.
Okay. Number 4.
I travel out of town for work.
All right. What do you do?
I'm a musician.
And what is happening out of town?
We have a gig. So we do multiple gigs throughout the weeks. And so if I miss, the rest of the band misses, then the bar loses out on their money for us performing.
All right. What's the gig?
I'm a musician, so I'm a guitar player. We just do.
No, I mean,
shows.
where is it? I know you're saying there's a gig, but where is this gig?
We have one in Pflugerville and then one in Granbury coming up.
When is the date in Pflugerville?
Pflugerville is this Saturday, Monday's Granbury.
Okay. All right. Thank you. Number 5.
Yes, ma'am. Traveling to Wichita, Kansas on Friday.
Okay. What are you doing in Wichita?
My son is visiting a university over there,
Oh, what university?
Friends University.
Has he looked into LSU?
He plays, I'm sorry.
Or UTSA?
I wish he would. He plays football and he's getting recruited for the school there. So
Oh, has he looked at LSU? What position does he
he's a
play?
quarterback.
Oh, has he looked at LSU?
Yes, he has. He has.
Good
I'm hoping
cooking?
UTSA will pick him up, so we don't have to
Oh,
move
yes.
him, but hasn't happened.
There's somebody here from UTSA right here.
I'm all
All right. All right, number 15.
Doctor's appointment Friday in Minnesota.
Okay. Number 16.
Yes, ma'am. I'm a pilot. I've been to work since the 3rd. I kind of need to go back the 23rd. Or stuff might still get canceled, delayed, people moved around. It's not a huge deal, but I would like to.
Who might you pilot with? Is this United or what?
No, ma'am. It's a small container line at Southern Air Express.
Okay. All right, number 18.
I have an uncle who just passed. He was the primary caregiver for my aunt who has dementia.
Mhm.
And I'm trying to help my cousin right now. We've been taking turns days. Yesterday, we had to find someone random. So I need to be able to go help my aunt with dementia. She can't stay by herself.
All right. Number 25.
I don't think it's gonna, she said, oh. Oh my gosh. Look for everybody.
Yeah. There's still a chance to make up.
25th, it's next Tuesday, but I just thought I'd raise my hand anyway, and I'm going to Denver. I could probably read my flights, but
All right. What are you doing in Denver?
just visiting some family.
Getting away from the hot weather here?
Yes, exactly. That's it.
Okay. All right.
I
Thank you.
can move it if I need to.
All right. So July 25th.
Yeah, and that's Tuesday. So.
All right. Thank you. Number 28.
I have a lab appointment on Friday. And then a doctor's appointment the next Friday.
It's her fault. She started it. Okay.
Lab appointment on Friday and then a doctor's appointment on the next Friday.
Okay. All right. Thank you. Number 30.
My boss is in town right now. He came from home today, actually. We're going to be doing tomorrow.
I'm sorry. Could you keep your voice up?
My boss is in town right now. He came in town today and he's leaving tomorrow.
Oh, do you really want to meet your boss?
I'd like to meet. Okay.
All right. Number 34.
I have a ticketed event in Dallas that it's non-refundable on Friday. And I also have a doctor's appointment on Monday.
All right. And what event in Dallas?
It's to see Shania Twain.
All right, man, I feel like a woman. Okay. Number 35.
Yes, ma'am. I have an appointment today at 1 o'clock.
Okay. All right, 37.
Friday through Sunday, my family's taking our family vacation,
Oh, where are you guys going?
to Kalahari,
Where is that?
up near, outside of Austin, like Round Rock.
All right. And do you want to be with your family or do you need a vacation from them?
Yes, I have 5 children. So why-
Okay. Thank you. Number 47.
My 7-year-old has a doctor's appointment on Friday. It's a very long time for us, so I'd really like to go to that.
All right, thank you. Number 48.
I fly out to Mexico on Monday.
Oh, what are you doing in Mexico? Okay, all right, thank you. Number 49.
I got family vacation in Florida. We leave on Monday.
But if the flight is canceled, you would feel mighty bad not doing this, right?
So, yeah.
All right.
Maybe good.
Okay. Number 64.
The Church of God in Christ, and I'm in Holy Convocation. It started yesterday. I've already paid for Rome in Waco, and I've already paid for the rental car.
Okay, all right, thank you. Number 70. All right, what is your field work? What do you actually do? Okay, all right. All right, so you've all, see, now people know that nothing bad happened when people said something. So now they're raising their cards. Okay, 62.
May not matter. Tuesday, I'm heading to Lubbock for work.
All right, what do you do?
Medical sales.
Okay, number 68.
I had family coming in from Pennsylvania on Friday and they're staying.
All right, thank you. And
I'm sorry, I just remembered I have court date on Monday for a traffic violation.
okay. Is that downtown at Frio?
I believe so. I have the paperwork. I can provide it.
No. I just wanted to know. Because if it is, that's right down the street. All right. All right, so you all have had a chance to hear each other talk and probably look at each other in the hallway from yesterday and downstairs and back outside today again. So other than meeting each other in the hallway twice and downstairs, is there anyone on this panel that knows anyone else on the panel other than meeting downstairs in the jury room or in the hallway? See, it needs to be an even number because otherwise somebody's not claiming they know someone. All right. Oops. Don't be, oh, you're not? Okay. 33, 35, 46, 54, 59, 60, and 70. All right, number 33, who do you know?
I don't know where he's sitting.
Oh, wait, okay, so you all work together?
Yes.
Number 35, who do you know?
Mary Exxon,
Where is she? Number 70? And how do you all know each other?
family. My sister was her sister-in-law's partner.
All right, any bad blood?
Yes.
Oh, there is bad blood between you two?
Yes, yes.
All right, thank you. Oh, that's the first time. All right, thank you. Wow. All right, that's the first time we've had that. We've had ex-wife and wife on the panel before, but everybody was happy with their positions. All right, number 46.
I just have a passing acquaintance with Carlos over here.
Who's Carlos? Number 60? And Carlos, is that who you know?
Yes.
All right. What, how do you all know each other?
He used to work at USA as a trainer in
Mhm.
the fitness center, and I see him there all the time.
All right, no bad blood.
No, no.
All right.
None of my clients, so
Okay.
Yeah.
All right, thank you. Number 54.
I work with Titan.
All right, who's number 59?
33.
33. All right. And then 59.
Couple people.
Oh, who do you know? All right, could you raise your card if you know her? What's your number, miss? All right, 71. How do you know number 71? Oh, okay. All right. Oh, what do you sell at your store? Okay, awesome. All right, and who else do you know? Number 59.
I gone to your store.
All right, that's 35. All right, number 60. And I'm assuming that's number 60? Number 60? 60. Yes. All right. I'm assuming when you raised your card, that was the person that you knew. All right. Thank you. All right. I'm going to tell number 37. Who do you know?
The gym is AMY.
All right. And Carlos, is your number 60? Everybody knows you, Carlos. All right. From the gym.
Yeah, so I also work at USA and I used to go stand in the gym.
Okay. All right. Number 64, you know someone?
Yes, ma'am.
All right. Could the person? Oh, how do you all know each other?
Through church, and then he actually dated my daughter.
Is there any bad blood?
No. Oh, nice.
Okay. All right.
She's not going to call Ari.
All right. So I'm going to tell you all two stories, and both of these stories are true stories. I know I talked to you all about in the hallway about inconvenience, and I realized that jury duty is an inconvenience because you have to pay for parking. I'm not the person, or these attorneys are not the person who made the rule that you have to pay for parking. Then there are so many one-ways downtown. And when you see a building, you're just like, the building is right there. I finally found where it is. And now I can't just turn. If I could just turn, I would be right there. So I realized there's inconvenience. Then you're downstairs in the central jury room, and maybe they're not saying everything that you want them to say or giving you all the instructions. Then you're waiting in the hallway and it's hot. So I understand that. But when you think about it, those are inconveniences because your country only asks two things of you. One, they ask for you to serve on a jury. And two, they ask for you to pay for taxes. That's it. And when you think about it, jury duty, it's not like somebody's calling you up every month. So none of you all are going to be called back next month or even the month after that. So it's an inconvenience. And the reason why I say that, because it's not, I don't consider it a sacrifice. And I know I told some of you all, my uncle grew up in Grand Cane, Louisiana. He has since passed. And he was super, super intelligent. And they would skip him in class all the time. Skip, 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 skip. Now, mind you, when his brother and his sisters came after him because he was the firstborn, everybody knew everybody in Grand Cane, Louisiana. So all the teachers were saying, hey, we know you're our brother. You better be bringing the intelligence up in here. So Vietnam War breaks out and they're drafting all of the boys in Grand Cane. My uncle, because of the time period, he knew that there was not going to be anything for him. Nobody was going to hire him to be a computer analyst. And I will tell you this, when computers first started coming out and they were a big thing, my uncle was already on top of the computer, so super intelligent. So he goes to my grandmother and tells her that he is not going, because they were not going to draft him yet because he's underage. He said, I'm going to sign up because this is the only way that I have the chance to better myself and do other things, and I'll get to see the world. So if you can imagine my grandmother having to sign up for her firstborn to go off to Vietnam. And honestly, nobody in the United States, because geography has never been our thing, nobody knew At least my grandmother didn't even know where it was, but she knew that people were dying there. So she signs up for him to go. It's not where we are now, where technology is king, where you can email somebody and say, how's your day going? It's not where she could immediately pick up the phone and call him, because back in that day, they only had 4 numbers for their phone number, and you could not even dial. You'd have to pick up the phone, call the operator, and ask the operator to connect you with somebody. Couldn't do that. The only thing she could do is send a letter. And then she had a hard time with that because of technology. Again, you don't know where your son is stationed. You don't know if they're coming back home or not. You don't know what they're seeing over there. So that's a sacrifice. My grandmother sending off her firstborn to a war where she don't know where it is and waiting in the tiny town of Grand Cane, Louisiana, whether or not somebody's going to come knocking on her door saying, we're sorry. So I consider that sacrifice, and this is just an inconvenience. And again, unless the law changes, you don't have to go fight off in a war. You don't have to sign up for the military unless you want to be in the military. The other story I want to tell you is about one of my friends I went to law school with. She decided that she wanted to do civil law. My passion has always been criminal law. I always knew I was going to be an attorney and practice criminal law. That was going to be what I did. So we never got a chance to connect and see each other because on the civil side, she was always in the office working and I was always in trial, in court every single day. So one day she calls me and she says, she has jury duty. Let's do lunch. And I'm like, great, let's do lunch. So we meet for lunch when they go on recess for their break. And I ask her, how is jury duty going? She tells me it's going fantastic. Now, since I've become a judge, in my mind, looking back on it, how can it be fantastic? You're not with Judge Boyd. Okay, the laughter shouldn't be that great. But so she says, I am not going to be on the jury. And I said, how do you know that? She said, it's just like when we're in law school. I'm on the back row, keeping my head down, not saying anything. So I started laughing. And she said, what's so funny? I said, we're going to be able to have lunch every week because you're so going to be on this jury. So at 5 o'clock, I stopped by where they're doing jury selection. I'm like, how's it going? She's like, I'm going to be on the jury. I'm like, told you. So I tell that story to say this. The quickest way to be on this jury, or any jury really, is to remain quiet. Other than raising a sign saying, please select me for this jury, that's the quickest way to be on a jury. And I tell you that because the state and the defense have this small window to talk to you, and they're trying to figure out whether or not you would be a good person for this jury. And what I want you to keep in mind when they're asking you questions, the main question is whether or not, if you're selected on this jury, because everybody has things in their past, but the question for you is whether or not, if you're selected on this jury, would you be able to base any decisions you reach based upon the evidence that you hear in the courtroom? Does everybody understand? Because everybody just wants a fair and impartial jury. All right. Now, before I turn it over to the state, both the state and the defense are going to have 30 minutes to speak to you. Before I turn it over to them, is there anyone here who needs a restroom break or any type of break? All right. So this is what I want you all to do. Look to your left, please. Like in paper chase, look to your right. You are responsible for that juror. So I'm going to give you all a break. We're going to come back here at 11. Now, when we take a break, remember, everybody has to leave. Make sure you leave your numbers. If you need to use the restroom, if you find a stairway, wherever you go, there are restrooms on either side of the stairway. So if you see it's crowded, you can go up or you can go downstairs. But remember, 4th floor, 187, Judge Boyd. All right, everyone, please rise for the jurors. Oh, you may leave. Yes, okay. You're welcome.
I'm not this either.
Oh, that's good. All those cases you dismissed.
What's your one next?
Well, I did that on purpose. I was like, I'm not gonna give you anything that's what he just said. It doesn't make sense, like to jump in.
Consider it.
What do you mean?
You were.
Well, he was the one that helped me put him on yesterday. So he was available to as far as I know. And that's what we were. Told to you, so. Honestly, I don't even know. Unless you down. So, 3 times he started coming over here. Mm-hmm. I was thinking that too.
All right, everyone, please be seated. All right, and State, are you prepared to proceed?
Yes, Judge.
All right, you may proceed.
Thank you. So first off, can everyone hear me? Okay. If at any time, if you cannot hear it, please let me know. It won't hurt my feelings. So my name's Daniel Escobar. I work at the Bexar County DA's office. We represent the state in criminal matters. And this is my partner, Hank Wilkins. So right now, what we're doing is what's called jury selection. Okay, there are 3 goals of jury selection. 1, we're going to teach you guys a little bit about the law. There's not going to be a test at the end, so don't worry about that. That's not going to come up. 2, we're going to find out a little bit about you guys. Now, what that means is I'm going to start calling on some of you. Okay, might disappoint, I might describe you. I'll try my best. But I'm just going to ask that you answer the question being honestly. Now, again, if you guys have some like flashbacks at elementary school and the teacher would call on you, I apologize. It's not my intent, but that's really the only way to make sure that I get this information from people. Okay. 3rd, the goal is for both sides to be able to pick a fair and unbiased jury in this case. So what does that mean? The ultimate question is can you be fair and unbiased? So there's 2 questions that kind of go with that. It's why would someone be unable to be fair and unbiased? And additionally, why would a juror be unable to follow the law? I'll give you guys an example. Possession of marijuana. Juror number 1. Do you know who these people are? Well, juror number 1. Who are these people? And if you could speak up, sir.
Willie Nelson, Snoop Dogg.
Okay. Anyone else? Can anyone else raise your card? No, juror number 26.
Be Cheech and Chong, Snoop Dogg, Willie Nelson, Seth Rogen, and James Franco.
Nailed it. If you just keep standing up, sir. Yeah. What do they all have in common?
They all smoke,
They love marijuana.
and they're actors and musicians.
Okay. So let's say this was a trial for possession of marijuana. Do you think that any of these people could be fair and unbiased in that case?
No,
Why is that?
because that's what I believe. Like they're gonna be in possession of marijuana, they're not gonna be able to, somebody else is in possession, they have a like interest with each other.
You hear that? They have a like interest, a shared interest. That's kind of what we're looking for here. And you get the counselor, thank you. That's what we're looking for here. It's the fact that they all love marijuana. If it was a possession of marijuana case, they're just going to instantly say without even hearing a single fact, not guilty. So that's kind of what we're trying to talk about here. Because we all have biases in our own personal lives.
And that's normal, can happen. But what we're trying to see is whether those biases are going to affect whether you can be fair and impartial. It's going to get annoying because I'm going to say that a lot. Because at the end of this process, whenever we pick the actual jury, you're going to have to render an oath to give a decision based on the facts and the law. Okay, that's the ultimate goal. So, what's the offense? It's aggravated assault with a deadly weapon. So the first step to figuring out aggravated assault with a deadly weapon is to figure out what an assault is. So a person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to another. So the first part, intentionally, knowingly, or recklessly, it's called mental states. So there's three that typically go with it: intentionally, knowingly, recklessly. So intentionally, it's a person acts intentionally or with intent with respect to the nature of her conduct or the result of his conduct. Those are all the legal definitions. Boiled down, intentionally, it is your objective to engage in the conduct or cause the result. You intend to do it. Knowingly, you are aware of your conduct or understand that the consequences of your actions are likely to cause the result. You know it's gonna happen. Recklessly, conscious disregard of harm that might be caused by your action. So I have an example, guys. Juror number 19. So, ma'am, what is this?
What is it?
Yes.
It's a notebook.
Notebook, legal pad. I'm going to pick up the legal pad. What did I intentionally do? Yeah, I picked it up. It's easy. I swear to God. I swear it's not gonna. I'm not trying to trick you guys. I picked up the legal pad. Juror number 4. How would you know that I intended to pick up the legal pad?
Because you grabbed it with your hand,
Okay. What else did I do?
showed it to us.
Okay. Is there anything else I did?
Not that I knew.
Anyone else want to raise a card? Juror number 20.
You made a declaration that you were going to pick it up.
Right. I said I was going to pick it up. I picked it up in front of you. I waved it around. I intentionally did it. Juror number 20. Let's keep on this one. What is on the legal pad?
There's a cell phone on top of the legal pad.
That's just in case if you guys can't see. Sorry about that. I know in the back it's a little difficult. I'm picking up the legal pad. Okay, so we already covered. I intentionally picked up the legal pad, but what did I knowingly do? Sorry, Diana. I have that bad habit, guys. What did I knowingly do?
Since you pointed out that a cell phone is on top of the legal pad, you picked up the cell phone knowingly by picking up the legal pad.
Right. I picked up the cell phone by picking up the legal pad. I knew that by picking up the legal pad, I also pick up the cell phone. It's knowingly. Juror number 21. I'm just gonna toss this like right in the back into the crowd. Right? I'm not gonna do it, guys, because yeah, bad aim. But if I were to do that, would I be acting recklessly? How can you tell I was acting recklessly? Right, because there's a ton of people back there. I'm not looking where I'm throwing it. I know that there's high odds that I'm gonna hit somebody. I mean, probably poor odds because I'm not a good thrower, but it's what it is. So that's just examples of intentionally, knowingly, recklessly. Because we can prove mental states by someone's statements, by their actions, and by the surrounding circumstances. We don't need to read someone's mind to know if they knowingly, with intention, or if they recklessly did something. So let's go to the next part of assault. It's bodily injury. So it's bodily injury. It means physical pain, illness, or any impairment of physical condition. Now, ma'am, what's your juror number? Juror number 11. That's a wide range of things, isn't it? Okay. So if I were to go up to Hank and pinch him and it hurt, did I cause bodily injury? Okay. How would you be able to tell if I did that I caused bodily injury to Hank even after the fact? Is there a way?
By him saying ow, by getting a bruise, by it becoming red, by it becoming raised, any of those.
Perfect. You can say ow. You get a bruise. There'd be a ton of different things. I can maybe kick someone in the leg, break their leg. You don't, pain, it's an impairment. All these things, it's a wide range, but there's multiple different ways to tell if someone's in pain, if there's been bodily injury. Also, as I kind of made in the example with the pinching scenario, pinching, not that, painful, depending on how hard I do it. But that's the lower limit. It's any pain. It can be from any pain to someone having their arm cut off. Be a very wide range of things. Now, let's go to aggravated assault. So a person commits an offense if he commits an assault and uses or exhibits a deadly weapon. So now what's a deadly weapon? Told you guys I was gonna be teaching you a little bit. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury. Or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. I know that's a lot, so what does that mean? It's obviously a firearm. It's a deadly weapon. No one's going to disagree with that. But what's also caught in that first definition, a knife, possibly a bat, things where if you it by its intended use, well, maybe not a bat, but knife, by its intended use, if you're going after someone with a knife, you're using a deadly weapon. If you're using it the way it's intended. The other way, the second definition, is that anything in the manner of its use or intended use is capable of causing death or serious bodily injury. I think right there that captures things kind of like, man, if I went after someone and attacked someone, and I stabbed them in the neck, guess what? It just became a deadly weapon because of how I was using it. Does that make sense to everyone? Now, that leads us to what we call the elements of an offense. And specifically for deadly weapon, it's these things that we need to prove beyond a reasonable doubt. It's these things. On or about a certain date. We need to tell you when it happened. In Bexar County, Texas, had to have happened in the county. If it didn't happen in the county, it happened in Travis County, it should be in the Travis County courthouse. Defendant. Someone needs to be identifying who did what. Intentionally, knowingly, or recklessly, going back to those mental states, cause bodily injury, need to prove that something happened to someone, that needs to come into, and he used or exhibited a deadly weapon. Does everyone understand the elements? Now, here's the next step, and this is going to be something that will take a minute, but we'll get through it. I want you guys to read that question or statement. I think that all assault cases, even those with minor injuries, should be prosecuted. I'll repeat it again. I think that all assault cases, even those with minor injuries, should be prosecuted. There are 4 options: strongly agree, 1, 2 slightly agree, 3 slightly disagree, 4 strongly disagree. What I'm going to do is I'm going to ask who here is a 1, who strongly agrees with that statement. What I'm going to do is have you guys all raise your cards, and I'm going to count down all the cards. Whenever I say your number, you can put the card down, okay? Then I'm going to go to number 2 and so on and so forth. Everyone understand? Everyone have a chance to think of everything? Yes, sir.
Are we talking just all assault cases or all assault cases or all aggravated assault?
All
cases?
assault
Just
cases.
all assault cases.
Yes, ma'am. Okay. So who's the number 1? They strongly agree that all assault cases, even those with minor injuries, should be prosecuted. If you agree with that, raise your card. Give you guys a second. Okay. So I got juror number 1, 3. You guys put the card down when I say your number. 10, 17, 18, 22, 26, 40, 41, 42, 43, 47, 48, 54, 56, and 69. All right. Who's number 2? You slightly agree that all assault cases, even those with minor injuries, should be prosecuted. Yes. I got juror number 2. 5, 7, 8, 9, 11, 14, 15, 16, 19, 20, 21, 25, 27, 31 through 34, 38. Oh, 32 also came up. Your number 45, 46, 49 through 51, 58, 57, 65, 67, 70, and 72. Who slightly disagrees that all assault cases, even those with minor injuries, should be prosecuted? You slightly disagree. Okay. Got your number 4, 9, 12, or 6, sorry, I had it upside down.
Oh, sorry. Oh, wait.
Yeah, there you go. 12, 13, 23, 24, 28 through 30, 37 and 39, 44, 52, 55, 59, 60, 61, 62, 63, 64, 66, 68, 71, and 73. All right, last one. You strongly disagree that all assault cases, even those with minor injuries, should be prosecuted. If you agree with that statement, please raise your card.
What changed mine?
Okay. So jurors 53, 55, and 74. Thank you. See, painless. So I want to next talk about justifications or defenses. One of the big ones in assault cases, self-defense. What it is. A person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. So you're able to use force against another when and to the degree the actor reasonably believes force is immediately necessary to protect yourself from someone using unlawful force. Simple. But let's talk about it. Reasonable belief. That means a belief that would be held by an ordinary and prudent man in the same circumstances as the actor. So just to kind of clarify here, it's not did the actor think that it was reasonable? Because if it's up to the actor, well, of course they're going to think it's reasonable. They did it. It's a prudent man. Ordinary, prudent. In essence, common sense. So, self-defense boils down to these things. It's a reasonable reaction. With the pinching scenario, if Hank just immediately hit me with a baseball bat when I pinched him, not that reasonable. It depends on the circumstances. Maybe if it's a stranger, it's dark, things are scary. Yeah, it kind of changes things if it's what's reasonable, depending on the circumstances. Equal force. If all I'm doing is shoving you or punching at you, and you pull out a gun and shoot me in the head, is that really equal force? Are you meeting it as the same? Or are you escalating? And sir, can you raise your card?
Did they know that they had a gun?
Journal, or can you stand up? Sorry.
Did they know they had a gun when?
All these cases, all these scenarios, again, I'm just saying in general, but that is a circumstance that could play a part. That someone's knowledge of what's going on.
Excuse me.
Oh, sorry. You're number 58.
And how would you determine whether the person fears for their life regardless if the person has a weapon or not? Whether the person's larger, more intimidating, or knows how to fight?
That's again another thing that would a prudent person in that situation.
Did you use the term common sense when you said prudent earlier? You're assuming that everyone has common sense? I work with people long enough to know that that's not true.
I also do the same,
I
sir.
do, yeah.
So it's one of those things that we're assuming you have common sense. It's you looking at it. I know that's a weird assumption to make.
You can't assume that.
Again, that's something that we just
Yes,
kind of
I
have to talk
understand,
about.
I understand. Okay, but I'm just making sure.
But again, it's really right there. It's more, you have to look at the facts, look at the circumstances, look at the scenario. And it's not that specific person what they did. It's what would the ordinary prudent person, a reasonable person in that situation, what would they have done?
Isn't that what I just said?
I know, but I'm kind of reiterating.
I'm not trying to argue, sir.
No, I know you're not, sir. But it's kind of one way to just get back to it. I know you just kind of repeated what you said. That's kind of what has to happen. It's a little bit of a weird, it's kind of looking at things in a vacuum to a degree. You know what I mean?
I do,
Where
but that's not how things work either.
Again,
and not reality.
it's what the law dictates.
Well, okay, thank you. Appreciate that.
So immediately necessary. So let's talk about that. If someone were to say, I'm going to beat you up in a week, and they walk away, and then you run behind them and punch them in the back of the head, was it immediately necessary to do it? If someone was maybe disengaging from what was happening, they're trying to back off and like, whoa, 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 I'm not gonna hurt you. And then you hit them. Again, is it immediately necessary? Words alone aren't sufficient. So if I start insulting some of you, if I start saying things, we're all the way over here, like juror number 7, I'm all the way over here, and I say, I'm gonna kick your ass. I'm all the way over here. And I have to look at, is it sufficient for me just saying things for you to then take it up a level? Everyone understand? And you cannot provoke the difficulty. If you're the person starting it, you can't be the person saying, I'm claiming self-defense. You can't be the person to throw the first punch. You can't be the person who's starting everything and then say, well, I had to defend myself because they attacked me. Well, you attacked them first. Can't say that you're defending yourself. Finally, you must admit it to get it. What I mean by that is you have to say, I did whatever I did to defend myself. Punch them in the head. I shot them. I stabbed them. Whatever it is, you have to admit it. If you don't admit it, you don't get it. So now on to deadly force. So a person is justified in using deadly force against another. So you have to meet all those requirements for self-defense. You have to check off every single box and say, yes, all those things are true and correct, happened here. And when and to the degree the actor reasonably believes that deadly force is immediately necessary. So again, another reasonable belief that it's immediately necessary for deadly force. So there are some carve-outs in the law. So it's to protect the actor against others' use or attempted use of deadly force. If someone pulls a gun at you and starts shooting and you have a firearm, you're able to fire back. To prevent someone from entering the actor's occupied habitation or remove the actor from their occupied habitation. So if someone's trying to get into your house, deadly force. If someone's trying to get into your house and take you out of your house, deadly force is again authorized. Or to prevent someone's imminent commission of aggravated robbery, kidnapping, sexual assault, robbery, and murder. So if they're committing any of those crimes and you're trying to stop them, again, that's another area where self-defense and deadly force specifically can't be allowed. So I wanted to talk about a little bit about deadly force, or well, first let's start with self-defense. Is there anyone here who has ever had to defend themselves from someone trying to attack them? Where they've had to say, I had to defend myself. I had to use the self-defense claim. If so, please raise your card.
In court?
Huh?
You mean in court we had to defend ourselves or just in general?
In general, in general. Thank you, thank you, juror number 18. So I'm gonna ask you guys some questions. What I'd ask is that you guys keep the cards up, okay? Or else I'm gonna lose track of you all and it's gonna be very hard for me to figure this out. So juror number 1, when did you have to defend yourself?
I'm sorry, could you speak up?
Yeah,
For
that was
record.
a long time ago. Middle school, I guess. Someone was trying to on me or something like that. Maybe started to be physical. Then I had to do something about it. I can't just let them overtake me in a sense. So
Right. So someone was trying to harm you and you did what you had to do to stop that harm. Okay. Were you the one that started it? Okay. You didn't get like a brick and hit them, did you? Or what did you do back? Yeah, you met them with equal force.
yes, correct.
Okay. You said middle school, did you have to report that to the school or anything?
So it happened in the restroom. I just happened to go to the restroom. They were in there. I was trying to, I guess, manipulate the whole interaction or whatever. Had like a people posse there, and they didn't do anything, but it was kind of like they were just trying to, I guess, intimidate.
That was that.
That was it.
Okay. Juror number 4, when did you have to defend yourself?
It was about a month ago, kind of the same situation, words exchanged and the other party got upset. So they came after me, but it really led to nothing much.
What did they do? What did they try and do?
They tried to like push me down, knock me over.
Okay.
So I just defended myself in that way, stopping them and it didn't go through. Yeah.
Did you end up reporting it to the police at all?
No.
Good. Juror number 8. What about you? When have you had to defend yourself?
Yeah, I was getting water, in those water jugs, parking lot, and, like these, I was finishing the water in the truck, and these two, big guys, running out of slow. And, they look at the car, and they look at the surroundings, and then they look at me, I'm already in the truck, trying to leave. But then, one of them comes up at me, and then opens the truck door and like grabs me from the shirt. And then, like it happened so quickly, I think I punched him in the face and I got left the truck, running. And, I was like, dude, what are you doing? And, the guy was like, you're trying to rob us or something. Like, what? No. And then the other guy's like, come at me. And then, they were like, oh, sorry, wrong person. And then
Did you end up reporting that to the police?
I was just so tired that day. I was like, I'm just gonna go home.
Okay. Juror number 10.
Well, in the military.
Okay. All right. Juror number 18.
About 6 weeks ago, 6 months ago we have a ranch in South Texas and was there by myself and had 3, I guess I'm supposed to say migrants that came undocumented. And so tried to break into the house. So I held them at gunpoint with the shotgun, called Border Patrol, and Border Patrol came and took them.
So you ended up reporting it to the police?
But I mean, it doesn't matter, but yes, they did, they did come and take them, but there's been nothing else since then.
I'm glad that went okay for you.
Right.
Juror number 21. In high school. So was it similar to juror number 1? Juror number 24.
One of my friends.
5
got
minutes.
into a Argument with somebody else, and it was kind of like our friend group and a couple of him and his friends, and kind of started a little shoving match, and then little smaller kind of shoving matches broke out, and I just happened to be in one. I got shoved, but it didn't really get anything serious.
And I'll skip to my next question that I was gonna have. Has anyone ever had to use deadly force in defending themselves? Or the prospect or threat of deadly force? Juror number 44.
Several years ago, I was at a stop sign, my wife, guy runs out and opens the door and tries to grab her out of the car. So I pull my gun out and he got the message.
Okay. Did you report that to the police? Juror number 45.
Well, this happened, this didn't happen when I was coming up from elementary school back in New York in the Bronx. Had some bullies that just come around, try to start some trouble. We got into scuffle, like young kids, probably like 9, 10 years old, things of that nature. And I mean, by just defending yourself against bullies and stuff like that, that prevented further things from taking place. But now I'm moving into the future, now as an adult, and I have a job that I work in medical field. And this thing overlaps into stuff like whistleblower situations, stuff like that. I'm going through a situation right now, job where physical altercation hasn't happened there. A lot of verbal stuff, a lot of underlying stuff that I believe is criminal. Because me being in the medical field and also being with the military, I look at patients in a way where patients normally can't defend themselves if they don't know what's going on. So you have to be the one to intervene and prevent things from happening. And like I said, this situation's been going on for years, let's say 10 years or more. And my situation is, since I am a whistleblower in the medical field, and I've had people released from the jobs where I work at and stuff like that, these situations have been ongoing where I've been getting targeted for certain things that I've done to help patients out. And still to this day, I still deal with that stuff. I have to try to figure out what's the best legal course of action to make sure certain things are stopped. When I say whistleblower, I'm talking about stuff that's happening in the medical field against patients that they don't have no knowledge about this, and I have to intervene and try to protect them. And when I do that, that's.
All right, thank you. All right, thank you, sir.
We understand, sir, and thank
All
you.
right, you have 1 minute, 30 seconds.
So typically with deadly force, from that one gentleman's example, when he had to defend his wife, there are certain things that you could possibly expect someone to do. Right there, that gentleman, I believe it was journal number 41, 44, thank you. He ended up calling the police. He ended up pointing at the person, ended up reporting it. That's something that you could expect. Generally, right now, just to cover, beyond reasonable doubt, it's not 100%, it's not beyond all doubt. It's, is there a actual doubt that is reasonable that goes towards the elements? I wanted to cover that really quickly before I had to sit down. Thank you guys for your answers, and thank you guys for your patience. Thank you.
All right, defense, are you ready to proceed?
Yes, Your Honor.
All right, and ladies and gentlemen, just so you know, the person to my left is an intern from UTSA. All right. All right, and could you state your name, please? All right, and does anyone know her? I know Mr. You.
Are you a justice major?
All right, thank you. All right, state you may
There's a
proceed. I
quiz
mean,
right
defense, you
now.
may proceed. Defense, what we can do, if you want to put it on the computer over there. Do you have a thumb drive or something?
I do. If you give me a second. Yeah, let me try one more time.
Try old school.
And ladies and gentlemen, just so you know, both parties did check out the equipment. Sometimes the equipment will work when IT comes down, and then sometimes it does not work. So both parties did check their equipment beforehand. And it was working.
Hold on, there's the
Number 62, yes.
Yeah, I'm sorry. I read Sarah earlier. If I trip next week, I can cancel it. Just want to make sure I didn't say it earlier.
Okay, thank you so much. All right, thank you so much. I appreciate that.
display.
Should we usually do it? Yeah, that's sounded.
There you go.
There we go.
Yes. Yay.
Yay. Right.
All right, defense, you may proceed.
Thank you, Your Honor.
Did it shut down again?
No, it did.
Okay.
Good afternoon, ladies and gentlemen.
Oh, come on.
Good afternoon.
Good afternoon, ladies and gentlemen.
Yeah.
Thank you very much. I appreciate the time you've taken in being here today and yesterday and being patient. As you've heard from the judge and from the state, this is a very important part of the court system and in trial, is getting to know who you are and how you feel about certain things, okay? We want to get that information up front, so when you get decided or you get selected to be a part of the jury, we're not surprised too much by what might happen back there. Obviously, whatever you decided back there is between the 12 of you who are on that jury, but we want to try to get that information ahead of time. And part of it is we all have things that we've experienced that affect our ability to view certain things. Our experiences shape us and how have an impact on how we view it, how we understand it, how we proceed on it. Okay. So part of it is I've gotten to know you a little bit from your questionnaires that you filled out. So I'm going to tell you a little bit about myself. As you heard, my name is Leo Gonzalez. I am a criminal defense attorney with Dunham & Jones Law Firm. And as you heard, sitting with me is Jessica Gonzalez, one of our associates as well, that works there at the law firm. Okay.
I did used to work at the Bexar County District Attorney's Office for 5 years. And I worked prior to that at the Nueces County District Attorney's Office for another 8 years, okay? So I have a lot of experience in working with criminal cases. I have 2 kids and my wife is also an attorney. I can tell you that in participating in trials, we never expect the expected. You never know what's going to happen, okay? Everything that you expect to happen never usually happens according to plan. So part of that is trying to figure out who you people are and what you see. Also involves getting to know the people that are involved and participants in the case. Now that I've introduced myself to you, does anybody here recognize me or know me? Okay. Does anybody here know Ms. Gonzalez? Does anybody here recognize my client, Mr. Roger Saucedo? Okay. Does anybody here know anybody who, other than the 2 individuals working here from the district attorney's office, knows somebody or has a relationship with someone from the Bexar County District Attorney's Office? I'm going to go through some names of potential witnesses and let me know if you recognize any of these individuals. A Zachary Specs, Officer Castillo, Officer Mendez, Officer Bush, Officer Sanchez, Officer Ling, Officer Cortines, Officer Patton, Officer Sohn, real quick. There's several people on this list, so let me just kind of run through them. Officer Figueroa, Officer Hales, Detective Remmers, Officer Cortines, Detective Mondragon, Detective Rivera. Anybody know any of those individuals? Okay. As you heard, the process is not meant to be prying. We're trying to get that information. We want to find out who can be fair and impartial, open-minded, be vocal, to be truthful. As you heard, you took an oath earlier, to answer all questions truthfully and honestly, okay? And sometimes when we go through things that we are discussed, especially when you hear from the judge, you may have a certain answer. It's kind of like talking to your mom and you're going to say, yes, I agree. Yes, I understand. Yes, I follow. And that's because the deference that she does deserve. But when you are asked the question again regarding certain aspects of the case that we're going to touch on and the state has already touched on, maybe you have a different opinion just because it's not your mom asking you. It's a little bit different. So some of these things that I may ask you may seem repetitive, but it's just to make sure we understand and we get the most truthful answer we can get from you, okay? What is your job? As he told, is to give answers to the questions we ask. Render a true verdict if you're selected to be one of the 12 jurors on this particular case, based upon the law and the evidence, not your experience, but the law and the evidence that you have before you. There are no right or wrong answers, okay? So there's nothing that you can say in here at this point. It's like, we're going to judge you for your answer. We just want to know what your true feelings are. And we're not trying to change any of your opinions or feelings. We just want to get what you feel about these particular types of issues. This is a very short time to get to know you, okay? So we're going to try to run through it as much as possible. You saw the state did one, had their educational part and try to get to know you. I'm going to try to do the same thing. Part of it is after this part of the trial, we're not going to have an opportunity to talk to you. So you're going to see me in the hallway, may say hello, and I may not say hello back to you. It's just part of the process. We cannot communicate after this process. And it's just because we don't want to have any appearance of impropriety with any of the jurors. So we are going to try to get to know you as best we can during this short amount of time. It's not a citizen test. We're not asking you to answer questions as to how well you know the law, how well of a citizen you've been, how well you follow the law. We've all done things in our past, in our actions daily that maybe not everybody agrees with. But it doesn't mean that you can't be a good juror. And we want to know those things so we can see if you're appropriate for this type of case. We expect you to be critical and skeptical, okay? As a juror, that's one of the things that's important, not to just accept whatever's given to you, but to look at it and consider what exactly is the state trying to prove. As you've heard already from Judge Boyd, the best way to get on the jury is to be quiet. I'm looking at you, juror number 6. You've been pretty quiet so far. Maybe we'll get some answers out of you here shortly, okay? Maybe not, I don't know, we'll see. You think so? She's still being quiet. But the thing is, it's part of it is because we don't know what you're gonna say. We don't know what you're thinking at that point, right? So we try to get through everybody as much as we can to try to get some information so we know what you feel. And then, like I said, there's no right or wrong answer. Sometimes people don't want to answer a question just because they're not unsure. They don't want to put themselves out there, and that's okay. But we have a duty, and I have a duty specifically to Mr. Saucedo to find out whether or not that information would affect how you view this particular type of case. So if I ask you a question or follow up on something, I'm not trying to pick on you. I just want to get that information so I can do the best thing I can for my client, okay? How many of you have a certain feeling, or how do you feel about trying to figure out a private dispute between two private citizens? Anybody have any feelings about that? Juror number 68.
It's none of my damn business.
Okay. Juror number 33. You don't? Anybody else? Juror number 4.
I agree with them.
You agree with them? Juror number 18.
I agree too. It's not my business if it's private.
Juror number 40, 42. Okay, so when do you think that becomes your business as jurors? Anybody? Juror number 26?
When they put it on you, like when they come at you with it and ask you questions about it.
Okay, and as jurors, when do you think it becomes something for you to have to figure out? Juror number 47?
Somebody gets hurt,
Somebody gets hurt.
they have done something illegal.
Juror number 15, something illegal. Juror number 19, I'm 61, I'm sorry.
When we are, if we are chosen and we hear the case, we go through the deliberation process.
Okay. Juror number 56.
Age. I'm sorry. Results. Their
That's-
age, if they're minors or children, not be able to help themselves.
Okay. Juror number 45.
I want to get a clarification of that, because my situation basically is not one person against another, it's one person against the system.
Okay, I understand that, and we'll try to get into some of that later on, okay? But right now, juror number 25, you got something?
I guess, I mean, when it impact, I don't think it's any of our business, like people are saying, except for if it affects us. If my neighbors next door fight all the time and argue with each other, that's their business until something happens that makes it my business, like they're in my yard and then they have somebody else that's come by and it's impacting my life and then it becomes my business. Or if it's, like you said, illegal,
Juror number 12.
I agree with the other woman where if, it becomes your business when one of them can't advocate for themselves or.
Okay. So basically, if you feel like either somebody's been wronged or somebody claims to have been wrong, right? It then becomes your issue here in court, right? As much as that may be the case, how many of you feel like you can make a decision about something that happened between two people that you didn't see? Where you feel comfortable making a clear distinction as to who's right or who's wrong in this particular case? Does anybody feel like, Mr. Gonzalez, I understand that now that I'm potentially a juror and I have to figure out what happened in this dispute between two people, potentially, I can't do it. Anybody that feels that way? Juror number 59, 60, 51, 22. Now, what kind of knowledge or training do you think it takes to figure out something like a dispute between two people? Anybody? Juror number 9?
Good interview skills.
Interview skills. Well, let me ask you this. How many of you have to figure out disputes between people in your life right now? I would hope all of you would raise your cards, because whether you have a relationship, whether you have kids, whether you work,
whether you go to school, at some point, you're gonna have to figure out a dispute between two other people, right? So you have that knowledge already. So it's not something that we're asking you to do that you can't do already. For those of you who said, I can't do it, explain to juror number 60, why do you feel like you couldn't do that?
I could do anything I want to do. I hate doing it.
Okay, and why do you feel like what was it that you hated doing about it?
I don't like confrontation, period.
And that's understandable. Not everybody wants to be a part of confrontation. And that leads me to another point. If you're selected to be a juror, at some point, you're gonna have to make a decision as to whether or not it's been proven that Mr. Saucedo has been proven beyond a reasonable doubt that he's guilty or not guilty, okay? What's the opposite of guilty? Is it innocent or not guilty? Okay, so what's the opposite of, what does that mean? That means the state hasn't proven beyond a reasonable doubt what they've been asked to prove or what they've brought to you to prove, correct? Right? So if they haven't done that, then it's possible that somebody could be not guilty, correct? Sometimes when jurors get back there, they feel the pressure from other individuals who have one way or another feel like they either have a stronger personality, they have a stronger conviction, and they want to go along with that just to move things on and avoid confrontation. How many of y'all feel that way? If you're selected to be a juror, you're just going to vote whatever you need to vote in order to avoid confrontation. And if you feel that way, please raise your card. Juror number 3. Anybody else? Like I said, there's no right or wrong answer. I just want to know if anybody feels that way. Juror number 8. All right, next question. How many of you have on this panel have ever been falsely accused of criminal conduct? Juror number 55, 58, 66, 44. Those individuals who raise their card, do you feel like that would affect your ability to be fair and impartial on this kind of case? And if you do, please raise your card. Juror number 58. Juror number 40. Anybody else? 66. How many of you have yourself or a close family member or friend been a victim of an aggravated assault? Please keep your cards up. Juror number 4, 5, 7, 9, 10, 18, 20, 21, 23, 24, 26, 37, 40, 41, 47, 49, 50, 55, 56, 57, 59, and 60, 61, 66, 67, 69, 70, 71, and 73. Of those individuals who raised their cards that they themselves or had a close family member or friend who had been a victim of an aggravated assault, how many of you feel like you could not be fair and impartial on this type of case because of that experience? Please keep your cards up. 18, 21, 15, 18, 21, 23, 26, 18, I got you, thank you. 40, 41, 47, 49, 50, 59, 69, and 73. As you have seen, whenever you enter the courtroom, we stand for you. Okay? And you'll notice as well, whenever the judge comes in the courtroom, we stand for her. Does anybody know why? Okay, respect. Well, yes, exactly, respect. In this regard, there are two judges, the judge of the law and the judge of the facts. Judge Boyd is the judge of the law. So when she comes in, we stand for her. When the 12 jurors are selected, you are the judges of the facts. And so to show respect for you and honor for you, we stand for you, okay? You're going to take an oath if you're selected to follow the process of following the law. You're going to take it even if you believe that you can't follow the law. It's basically 2 oaths. Like I told you, 1, to tell the truth right now, 2, to follow the law if you're on the jury. Does anybody think it's fair to take an oath and then not follow that oath? If you take an oath, what is an oath? Okay, so if you're taking an oath, making a promise, you're making a promise to the state, defense, and the judge, first to tell the truth, and second to follow the law. Can everybody agree to that? How many sides are there to a story? 3. Why? Everybody says that 3. Oh, there's the one side, the other, and the truth, right? That's kind of we got where we get to now. But typically there's always an agreement between 2 sides of a story? Most likely there's not, right? Right? Every day, yes, there are jurors that find people guilty. But what's the other side of that story? Are there people that are found not guilty? You've heard about the indictment. Indictment is not evidence of guilt. How many of you here have ever served on a grand jury? Juror number 20, anybody else? Juror number 36? Juror number 19? How many of you have ever served on a criminal jury before? On a criminal case? And keep your cards up if you have. Juror number 3, number 19, 20, 30, 31, 44, 51, 65, and 67. Of those of you who raised your cards that you've served on a criminal jury before, how many of you were able to reach a verdict? If you have we were able to reach a verdict, please raise your card again. Juror number 19, 30, 44, 51, 65, and 67. As you heard, the indictment is just basically permission for the state to prosecute the case. It's like a traffic ticket, bringing you into court. Witnesses aren't called before the grand jury, isn't that right? Juror number 20? Who presents evidence in the grand jury? The state, right? The law is going to state that each of you must decide the case for yourself, but only after discussion and impartial consideration with your fellow jurors. You're not advocates for one side or the other. You don't have to, oh, well, I need to see what this side says. You look at it how you see it and then make a decision, okay? Is there anybody here that feels that they cannot do that? It's not a democracy once you're selected to be a juror. Everybody has the same power. Everybody's going to be able to make a decision. You can stick to whatever, even if you're in the minority. So I'm going to ask once again, is anybody feels like if you're in the minority in a decision that's being made about Mr. Saucedo's life, that you won't be able to hold on one way or another? They won't be able to stick to your convictions because you're in the minority. Anybody here feel that way? Okay. Heard the burden of proof. There's preponderance in civil cases, clear and convincing in child termination cases, termination of rights. Beyond a reasonable doubt is what in criminal cases, right? And we heard that there's no real definition, okay? And how many of you heard the old saying, if a tree falls in the woods, doesn't make a sound, right? Now, what is reasonable that it normally would do if it falls? Okay, but if you were presented facts that indicated to you that somehow that was done carefully in order to indicate that it did not make a sound, and it was presented to you directly, is it possible? What if the facts provided that to indicate that that's what took place?
But it's against common sense.
And if the facts are in front of you to indicate this is what took place, and that's what's provided to you, and you review that, can you consider that at that point as to whether or not it's reasonable doubt? So is anybody here that feels like just because something is automatically common sense, that there can never be anything to refute that? Juror number 58? Juror number 18? Okay. It's none of these things. May be guilty, could be guilty, probably guilty, most likely guilty. It's has to be proven beyond a reasonable doubt. If that doubt is not proven, if that state hasn't proven that element beyond a reasonable doubt, then what is your verdict? Does a verdict of not guilty mean necessarily somebody's innocent? What exactly does it mean? Juror number 20, they didn't reach the burden of proof. Is there a verdict of undecided? Yeah, there is. You get to make the decision. If you don't feel like the state has proven its case beyond a reasonable doubt, then you can vote not guilty. If you feel like you're not sure, then you can say, I don't know. There's nothing wrong with saying you don't know. We want you to come to a conclusion, but if you don't feel like you can, it's okay to say that. Okay. What's the defendant's burden of proof? Juror number 9. Zip, right? Doesn't have any burden of proof. Doesn't have to put it on anything. Who cares about the defendant's rights? Besides me, who cares about the defendant's rights? Should we all, right? Why should we all care about the rights the defendant is provided within the Constitution? Juror number 40, I'm sorry, juror number 10?
Because without carrying your degree.
Graded the Constitution. Anybody else? Juror number 12?
It lessens the like your rights as well. If you don't,
Lessens
they would, why would you get it?
Juror number 63?
Never know when you're gonna be the.
That's exactly right. At some point, somebody could make an allegation against you. And so you want those rights to be fully followed and given the strength because it could be you, right? So whether or not you're sitting here, all of you could be charged at some point because you just never know when it could be you. So that means how much attention do you pay to the rights of the defendant then when you're selected as a juror? You give extra attention, right? Because it could be you that's being accused of doing something. They have a right to a fair trial, fair and impartial juror of their peers. They have a right to plead not guilty. Has a right to be presumed innocent. What exactly does that mean? We've kind of talked about it in a roundabout way, but what does presumed innocent mean? Which is?
She cannot hear, court reporter cannot hear everyone. Please make sure, you guys have been doing great so far. Please make sure you keep your voice up. And if you're not on any of those rows, please stand when you're answering the question.
So what is right to presumed innocent? Somebody said exactly what it says, which means what? Juror number 69? Right. Proven guilty. Okay.
5 minutes.
Thank you, Judge. Let's talk about a couple of things that the state talked about in regards to with possible defenses, okay? What you heard is something called affirmative defenses. What affirmative defenses are is that somebody says, yes, I did do the actions that I've been, or I did do some action, but my action that the result ended up being was justified, and it was justified in the law. So there are several that the state of Texas has given to somebody who's been charged with an offense. First one you heard of is self-defense. In self-defense and using deadly force, there's nothing that requires you to have do some other action in between using the force that's necessary. If you believe it's necessary to use that deadly force, then the law allows you to do that. You don't have to make a phone call to police in order to intervene. That's the whole point of the deadly force statute, is it's saying that you get to use that force because you believe that it's necessary to prevent something happening to you. There's also defense of third parties. If you believe that it's necessary to prevent something else happening to an individual that is close to you, or that's not even close to you, but you believe it might cause death or serious bodily injury or harm to that person, then you get to use self-defense of that person as well. That immediacy, it's not up to us to make the decision. As jurors, you get to see whether or not you believe it's reasonable, okay? Whether somebody believes it's reasonable, whether somebody believes if I'm standing here and I tell that person I'm gonna kick their ass, whether or not it's immediate or not that are required, that would be something for you to decide. Because you know what, if I'm sitting over there and somebody tells me to kick my ass, I'm gonna be immediately aware to be ready to fight and do what I need to do. Not just because it is far apart, because of what the actions are indicate to me, I need to be ready to take care of myself. If somebody threatens somebody on the other side of the courtroom, I'll be ready to protect that person. Not because they're far away from each other, because I feel it's immediately necessary at that point. Because I believe it's reasonable or what might take place. Is there anybody on this panel who, if you were in the defendant's shoes, would not want yourself on the jury? If you are, please raise your card.
I don't understand what you said.
If there's anybody on this panel who believes that you were in the defendant's shoes, you wouldn't want yourself to be on the jury.
Wow.
Because of your experiences, you just, hey, this guy, if I was there, I wouldn't want myself on that jury. Juror number 18, juror number 40, 23, 51. Anybody else? Is anybody here that believe that the severity of an injury makes a difference as to whether or not the state should charge it? So you believe the more severe the injury, I see most of you raised your cards. Most of you believe that the more severe the injury, then the state should go forward. Is that accurate? Does the severity of injury have an effect on whether or not self-defense is a viable claim for any of you? If you do, please raise your card. Juror number 58, 59, 60, 61, 62, 67, 72, 73, 41, 42, and 56. Going back to the
30 seconds.
Thank you, Judge. The punishment range, you heard it's 2 to 20 with the possibility of probation. Okay. Is there anybody here that feels like they cannot consider the full range of punishment in this particular type of case? 18, 23, 15, 23, 24, 47, 51, 61, 62, and 73. Ladies and gentlemen, I thank you for your time. I appreciate the attention you've paid so far. And like I said, this will be the last opportunity I have to speak with you. So thank you for allowing me to speak with you.
All right, ladies and gentlemen, we're going to take our break. The court reporter, of course, needs breaks for her hand because she's been typing down everything that everyone has been saying. You can have lunch in the cafeteria. There's also lunch along the Riverwalk, which are usually expensive places, but there are some good places that are along the Riverwalk that are not expensive. There are places along Houston Street. So there are restaurants within a stone's throw. I'm going to need you all lined up back outside at 1:30. And at that time, you will know if you will be selected on this jury. And then immediately after the jury is selected, we will start with evidence. All right, everyone, please rise for the jurors.